A continuación, le doy la palabra al señor Rasch, de Copinor, a quien ya presenté, como solamente eran dos, ya presenté antes, y para no romper el ritmo, cuéntenos cómo sucede en realidad este asunto de las licencias extendidas en los países nórdicos.
Well, first of all, I want to thank the organizers for inviting me to give a speech at this seminar. I will focus only on the Danish perspective, and my plane leaves at 1 o'clock, so I think I'll run quickly through my presentation. In Denmark, one has chosen to solve the orphan works problem by using the so-called general extended collective license in the Danish Copyright Act's Section 50, subsection 2. The story behind this is as follows. Prior to a media policy agreement for the year 2007 to 2010, the Danish Ministry of Culture established a committee on the digitalization of the cultural heritage. The committee consisted of representatives from archives, museums, libraries, the Danish public television stations, and right holder representatives from both authors and publishers. It quickly became clear that it was necessary to establish a copyright subgroup to identify the specific copyright issues. The copyright subgroup delivered its interim report already in April 2007. One of the questions which the committees focused on was how to solve the orphan works problem in the context of digitizing cultural collections. The committee's conclusion was that an extended collective licensing solution was preferable. The committee states, among others, that it, and I quote, "There are various solutions to the orphan works problem. The US and Canada are considering solutions where works can be used without the risk of punishment or compensation after a thorough but fruitless search for the rights holders has been conducted. Similar solutions are analyzed within the EU in different contexts. The copyright subgroup finds such a solution problematic. It is extremely difficult to determine whether a user has conducted a sufficiently diligent search in order to try to identify and/or locate the rights holder. There is a risk that the user is encouraged to use the works without a serious attempt to clear the rights in advance. Such a situation is unfortunate for both right holders, who are made more or less lawless, and who are left with the burden of proving that the user has not made a sufficiently diligent effort in trying to identify the right holders, as well as the users, who under such solution can never be certain of whether or not a large number of right holders may subsequently come to claim remuneration which has not necessarily been budgeted for. Against this background, the copyright subgroup is of the opinion that an extended collective licensing solution is preferable. And on specific proposals, the copyright subgroup said, and again I quote, "At the same time, a new extended collective licensing provision is to be implemented, which allows a user and a representative collective management organization to enter into a collective agreement with the extended collective licensing effect. This could be the case for areas of extended collective licensing that lie outside the areas currently covered by the specific extended collective licenses provisions. For example, one can imagine extended collective licensing agreement covering orphan works. An outside right holder shall have the option to issue an individual prohibition against being included in a license agreement under the new general extended collective license provision. The copyright subgroup proposes that the Ministry of Culture initiates an amendment to the Copyright Act in line with the above in the 2007-2008 parliamentary session. The Danish Parliament then adopted with effect 1st July 2008 an amendment to the Danish Copyright Act, which inter alia introduced a new provision in Section 50, subsection 2. According to Section 50, subsection 2, users shall be able to enter into agreements with extended collective licensing effect with an organization that represents a substantial number of right holders to certain types of work that are used in Denmark in the specific area of exploitation. The parties themselves define the area of exploitation. It is, however, a condition that the Ministry of Culture approves those right holders organization that wishes to enter into agreement with extended collective licensing effect. In approving the organization, the Ministry of Culture must ensure that the organization is representative in the applied field. The Ministry of Culture writes in the explanatory notes to the amended Copyright Act the following regarding orphan works, with reference to the work that the copyright subgroup that I mentioned above. One of the models could be that a user without the risk of criminal or civil liability can exploit works if the user has made a sufficient diligent effort in trying to identify or locate the right holder. One such model is appropriate in the opinion of the Ministry. It's not appropriate in the opinion of the Ministry. There is a risk that this approach does not give the user the necessary incentive to make serious attempts to trace and identify the right holder. It will furthermore be associated with some uncertainty to determine when users have made sufficiently diligent efforts in trying to identify the right holder. This assessment will ultimately have to be made by the courts, and therefore users will have no possibility to estimate any possible claims for remuneration which they may be met with at a later stage. This means that such a solution would lead to a significant degree of legal uncertainty for the user. So the Ministry's opinion is similar to that of the copyright subgroup, which is that the extended collective license would be an appropriate instrument in ensuring the necessary clearance of orphan works. The advantage of the extended collective licensing solution is that the license agreement between the user agreement ending collective management organization will achieve extended collective licensing effect, which means that the agreement is extended to cover all rights holders in a given area. This creates the necessary legal certainty for the potential user, and at the same time it ensures that the rights holders receive payment for the use of their works. It should be noted in this context that non-represented right holders will be able to issue an individual prohibition against a use that is permitted under an agreement reached via extended collective licensing terms. The Danish Copyright Act, Section 51, contains a special protection for non-represented right holders. Firstly, the rule that the collective management organization has established regarding distribution of remuneration to right holders who are represented by the organization must also apply to unrepresented right holders. Secondly, non-represented rights holders can claim individual remuneration even if such a right does not appear in the agreement with the user or in the distribution rules of the collective management organization. According to Section 49 of the Danish Copyright Act, a three-year limitation rule applies for such claims. Well, right back at the time of copyright writing's formation in the 1980s, it was decided that collected remuneration should be distributed individually to the right holders. The distribution of remuneration in copyright writing is based on statistical methods in which extra copies of copied material is reported to copyright writing. The documentation and research department in Copydan Writing is devoted entirely to register copied material and ensuring that remuneration is distributed individually to rights holders on the basis of the registration. So in a sense, we can say that the researchers carry out a subsequent due diligence search in order to find individual right holders. In most cases, we succeed finding the right holders because the staff has extensive experience with this work. Because of the nature of the extended co-license, remuneration is also distributed to non-represented right holders, i.e. right holders who are not member of any of the member organizations represented in the board of Copydan Writing. So this system is therefore totally transparent because right holders receive money if their works has been copied in Denmark. As Jukka mentioned, it's not a coincidence that ECL was developed in the Nordic countries. The legal thinking which ECL represents is in line with Nordic labor law. There has been a tradition for dealing with issues of labor law by collecting agreements between organizations representing employees and employers. But the cultural background of the ECL also seems to be that ECL is developed in countries which have a tradition for a high level of organizations. On top of that, the Nordic countries are small societies with a high degree of transparency and tradition for pragmatism. So if ECL rules have been successful, it's not only because of the design of the rules or the content of the agreements, it is also because of the context in which they function. If one, therefore, would seek to transplant these models into other systems, I think that one should be very careful. And thank you for your attention.